Welcome to the IEP Coach, where we are empowering parents and teachers across the United States to champion the success of every child. If we haven't met before, I'm Alan Driggers, the founder of the IEP Coach. Today we're going to talk about an area of special education that, from my experience, is often glossed over and misunderstood by parents, teachers, and even administrators. Procedural safeguards. So what are procedural safeguards? So these are the rights that are given to parents under IDEA. They aren't just paperwork that you get as a parent. It is actually the foundation for the accountability of schools and also allows parents to make informed decisions. Obviously, first area of procedural safeguard is very important. It's called child find. So this is the school districts have a responsibility to proactively locate, identify, and evaluate all children that are within their district or their boundaries. This includes homeschooled students, private school, if they're a ward of the state or incarcerated. All of those must still be evaluated by the school. The school is required to find these students. They are compelled and obligated by IDEA to find these students. There's different ways that could be done. Obviously, as a parent, if you reach out to the school and let them know that your child's having difficulty, that's one way. But there's also through doctors, professionals, other professionals that can notify the school. And the school, again, should be out looking for these students and making it publicly known that they're looking for the locate, identify, and evaluate of all students. Another area that is very often overlooked, which is important part of IDEA, is what's called prior written notice. So this is where schools must provide written notice before proposing or refusing to initiate or change a placement, services, evaluation, or in any way change their FAPE, a free appropriate public education. So a notice must include the description of the action being proposed or refused, an explanation of why the action is proposed or refused, a description of each evaluation, assessment, or record or data used in that decision making, when is notice required. It's required before the initial evaluation, before changing services or placement, when refusing parents' request, before graduating with a regular diploma, and before terminating services. So this is something that even if it's discussed in the IEP meeting, if there's a change being made, the school district is obligated to send a written notice of what those changes are and what they're proposing. So verbal agreement does not count as prior written notice. It's often overlooked in our schools because it's just not discussed. It's not anybody being malicious. It's just people don't know what they don't know. Another area of procedural safeguards is parental consent. It's required before the initial evaluation, before initial placement, or even a reevaluation. So a parent must give consent for their child to be tested. A parent has the right to choose some or all testing. So you have a wide variety of testing, everything from academic to psychological to speech therapy, occupational therapy. There are several service areas. As a parent, you have the right to ask for all of them or to ask for pieces of them. It must be done in writing. Everything a parent does should be done in writing, and so everything a school does should be in writing. Never, ever rely on verbal, because that is not, if you ever had to go into a hearing or had to file a complaint, defend yourself, if you don't have it written, it didn't happen. But consent must be informed and documented in the native language of the parents. That consent form must be given to the parent in their native language. Along with that, which I failed to mention earlier, the actual entire procedural safeguards is required to be in the parent's spoken language, native language. So I'm in Texas, and I know the state of Texas has 20 some odd different versions of procedural safeguards that schools can use, and they're in the different languages. And if there happens to be one that's not covered, there are different avenues that a school can go through to get that done. Also, there is, even in Texas, we even have a video for sign language so that can be used. Most people don't realize that, but it is safeguards should be in the native language of the parents. Let me jump back now to, we were talking about parental consent. schools have to document that they try to get consent. They have to show emails, documentation of when a parent refuses. School districts want to keep that records. Probably not so much teachers, but the district does at the district level keep that in case something comes up down the road where it's said for the district that you didn't provide their student FAPE, but you can document that you tried to get consent and didn't. The next is what's called an independent evaluation or independent education evaluation, IEE. So if you're in an IEP meeting as a parent and you disagree with the evaluation that the district provides, you can request an IEE. It is at the expense of the district. The district must allow for that. Once a year is when a parent can do that, or after an evaluation. That's the only time it can be done. The most it can be done is once a year. If a school refuses to do that, it's an automatic due process hearing where the school has to explain the reasoning of why they do not see an evaluation is needed. As a parent, you need to request this in writing via email, via letter, but it needs to be in writing. The district either will agree or decline the testing. That's when the decision of an independent educational evaluation can be made. Another issue that's covered in the procedural safeguards is discipline and behavior. So if you have a child who behavior could be a possibility of contributing to their discipline because of their disability, this is very important to know. You have what's called a manifestation determination review that is done by administrators, counselors, and you as a parent. You will discuss whether or not the behavior is a result of the child's disability, or did it happen because the school district or the school failed to provide with fidelity the student's IEP. And so those are two questions that are asked. And even if they are both yes or no, if they're both positive, I guess is probably a better way to say it, positive, in that the district did not complete did not fulfill the IEP or the student's disability is cause of the behavior, the district can still send the student to an alternative placement. That doesn't mean that automatically that's not going to happen. It definitely needs to be discussed. And as a parent, there are certain rights you have. There are a few things that are mandatory, automatic, doesn't matter. The discipline, anything involving a weapon, bringing a firearm, bringing something that's considered threatening or a weapon to school could automatically cause a placement to an alternative setting. Drugs and or serious bodily injury. So a fight, hurting another student, staff member that causes serious bodily injury will get a student placed off campus. But if they're not, even if they're out of placement, so a student goes to ISS, a student goes to an alternative school, the school still has the same obligation to provide the special education services they received before the disciplinary that they were getting in school. So those don't go away just because of a student's alternatively placed. And there could be a case where the student doesn't go because the school can't provide those services. So they must be provided. So that's an MDR. Those happen, again, they happen within 10 days of the decision of the discipline. So another area that's covered in the procedural safeguards is the transfer of rights from the parent to the student at 18. So what happens is that at 18, regardless if the student is still enrolled in a public school, hasn't graduated, the student now takes on all the rights to make their own decisions. I've often talked with parents, and it can be frustrating for a parent who the child the night before is 17, but they wake up the next day, they're 18, and it flicks a switch. Now they're making all their decisions. That's why planning is important. The school district should and is supposed to notify the parent when the child, at least 1 year prior to 18. So typically when a student is 17, a school district will notify when your child turns, they will now have the right to make their own decisions. So there are things that, depending on the severity of the disability of the student, parents can put into place. So there are legal arrangements that can be made. There is what's called supportive decision making that can be put into place, which does require an outside legal arrangement set forth. If that's not done ahead of time, before the child turns 18, the student then becomes the decision maker, even to the point of allowing the parents to attend the meeting. So that is something that if they're 18, they do not have to allow the parents to attend the meeting. So parents, you definitely want to stay on top of this, especially if you have a child that needs that extra support from a parent in making decisions on their own. It's a great skill to get them involved early, and they can have a voice before they're 18. And then it's still the parent's decision, but it makes the transition easier. So another area of procedural safeguards is the confidentiality and of the student's records. It discusses that. So under FERPA and IDEA, parents can inspect school records, request all amendments, all correspondence that involves their child, and must be informed of who is accessing those records. As a staff member, you want to make sure that you remain professional in communicating even from another student or an administrator about students, because parents have the rights to that. It's very important. A haphazard or a derogatory remark made in an email about a student because they're, for whatever reason, number one, it should never be done. But number two, everything that you're doing as a teacher to just cut your knees out from you. So parents have the rights to that. It is your child. It is your student. There is nothing that is proprietary to a school that has your child's name on it. That includes testing, any evaluation, anything. There is nothing proprietary. Parents have the right to everything. So again, that parent's definition is described at the very beginning of procedural safeguards. So another area that is discussed in procedural safeguard is when a parent feels a student is not getting the education, they're not getting a free and appropriate education at a public school, they can pull that student and place them in a private school. Obviously, you can do that at any time. The school can be required to reimburse the parent for that cost, but there are strict and definitive things that a parent must do besides getting a hearing officer to agree that the school was not providing FAPE. The number one is the district must have failed to provide FAPE. Obviously, we talked about that. Number two, the private placement at a school is appropriate. So if your student has a disability, you send them to a private school and there are no services provided at that private school, which is mostly the case in all private schools, unless they're a specialty school, which I know there are some for autism and different disabilities. But if it's just sending them to a private school that doesn't offer the services, that won't be considered necessarily appropriate for the student. The parent has to give notice to the district. They have to give it at least 10 days prior to the placement for it to be considered. And there are no other factors that the hearing officer would determine that reimbursement was unreasonable. Again, as a parent, you must give notice to the school. And obviously, a lot of this will come at an IEP. So at the IEP meeting or soon thereafter, you must state that you disagree with or rejecting the placement, rejecting the services being provided. You must provide written notice, at least 10 days. We talked about that. State your concern of why, if the student stayed, and why the new placement would be more appropriate. And you need to state the intent to enroll your child in a private school at public expense. So all that has to happen. And it has to be determined that your reasoning was valid. So that is something. There are some limitations. If you don't provide notice, it can be denied. If the district notified you, but you didn't make your child, they were going to do an additional evaluation and you didn't make your child available, and the court or hearing officer can find that what the decision and actions that a parent took was unreasonable. So the district is not required to pay for the education. They can provide. They can, if it's determined by a hearing officer. That is something that you're seeing more and more because of the school choice in a lot of states. Parents will try to do that. You need to make sure that you're doing it for a valid reason. As a parent, you have 4 that are discussed in the procedural safeguards, and there is a 5th that I'll discuss, but as far as dispute resolution options. The first one is file a school grievance, file a local complaint with your school district or school board. I would not recommend parents do that. It's usually a waste of time, and it cuts into your time for your other options. I've never found that a grievance typically addresses those concerns. But if you're having a disagreement in like an IEP meeting, you can request what's called an IEP facilitator, facilitation of the IEP, where you can request it from the state. and they will send a person to come and basically sit in the IEP and facilitate that, who is a neutral party, who has no direct involvement in the IEP. You can also request mediation, and those two options are very inexpensive. They don't require the need for necessarily an attorney. If you were buying a house, typically you'd want to get a realtor because most people don't buy houses or not understand real estate law necessarily. So that's an option to have an advocate like myself. Dispute resolution, you have the IEP facilitation and a mediation. Those are the two that you can request. The next two are a state complaint, filing with your state board complaint, or filing a due process with the Office of Civil Rights with the Department of Education, federal. Those are your dispute resolutions, and there are definitive timeframes on when you can file that. You always want to consider mediation first, okay? Go with that first. And you do have a specific timeline. Again, I talked about on due process, it's 2 years from when a parent or district knew or should have known about the issue, with the exception being if the district misrepresented, information is withheld. If a parent delays filing and misses the 2-year window, the case is automatically dismissed. Nothing will happen. But so as a parent, you need to track all communications. You need to act quickly. A lot of times you need to have somebody who's more familiar with it to help you out. But you do need to preserve the right to file through those timelines. You can a couple of things. You can request expedited hearings when it applies for disciplinary matters. If you're doing a hearing, hearings are legal procedures. So again, you do want to consider having some representation and advocate for that matter. Whether it be state or federal, can be appealed to the state or federal court within 90 days of the decision. So you have that option. Both parties have that option. The parents have it and the school has it. So the school can apply. And you'll see sometimes where on day 89, there's an appeal filed. Attorney's fees. Kind of last thing we'll talk about today about procedural safeguards. Attorney fees. So if parents prevail in a due process hearing, the court can award reasonable attorney's fees if the court determines that there was cause for the filing. Likewise, if the complaint is considered frivolous or if you're filed to harass a school district, the district can recover their attorney's fees from the parent. You need to be fact-based. It needs to be no feelings. I feel, I don't like that. None of that can be in there. It needs to be very specific, very succinct of a violation of IDEA, a violation of implementation of the IEP. Those are valid reasons to file, and it needs to be kept within those guidelines. Fees that are awarded are discretionary. They're not automatic. Courts may refuse to award attorney's fees even if the settlement, the party wins, the parent wins. They may not get them if it's considered that there was an offer that was reasonable and it was denied by the parents or denied without good cause. But like I said, frivolous filings, frivolous cases, parents can be on the hook for the school district's attorney's fees. So I would recommend on our website, www.theiepcoach.com, theiepcoach.com. But we have a section on procedural safeguards for parents, and we have a whole section for parents. We are happy to help you. You can reach out to us. We have a contact page. Feel free to reach out. We are here to help both parents and teachers. Myself, being been a teacher, special ed teacher, campus leader within the special ed or 504 realm, I understand teachers are often, there's so much to learn, and this is an area that there are very, very few times where I see schools teaching this and informing their staff, their teachers, of what is required, what is expected by law. And something to think about for my teacher friends out there. Whenever there is a hearing, a due process hearing, the responsibility goes back to that special education teacher to implement the IEP. It's not your special ed, your school psychologist. It's not the diagnostician. It's not your special education coordinator, your director, your superintendent, your principal. It's the special ed teacher. And so whenever there is a hearing, you'll be the one that's called in to testify of what you did or didn't do. It's not the administration. And so I don't say that to scare you. I say that to let you know you need to be informed. And my goal, as well as helping parents and students get what they rightly need and deserve, my goal with the IEP coach and what we want to accomplish is educate teachers in the areas that are not being taught currently in the school systems. I keep that in mind. I hope this information was informative. I hope it helps. We'll be doing more of these. Take care.